Good evening, it's Thomas Leonard Ross, KC, on the Glasgow Advocate Talks podcast. It's now a week since the UK Supreme Court gave its decision in the cases of Daly and Keir. A number of people have been in touch for my views in relation to it. I've waited a week for a variety of reasons. I was quite pleased with certain aspects of the judgment, but it's very complicated and I wanted to reflect properly on it before rushing to make any form of statement in relation to it. And having considered it, it's really almost impossible to summarise the judgment in 15 minutes. So I think I will probably do a series of podcasts in relation to different aspects of it, because it's really just very difficult to summarise it. So really what I want to do is give an introduction as to what it was all about, give an overview on what it means, and in particular give some comment on what happens next, a subject which hasn't really featured very much in the discussion up until now. The cases of Daly and Keir were both criminal prosecutions in Scotland for sexual offences, and when you're prosecuted in Scotland for a sexual offence, then sections 274 and 275 have application. We usually talk of them as the rape shield provisions, and again, far too complicated really to explain fully, but the purpose is to protect the complainer's dignity, to prevent the complainer being humiliated by questioning, which really has no proper purpose. The original rape shield provisions were introduced in Scotland in 1985, but then substantially tightened up in 2002. Introduced the idea that behaviour that wasn't sexual behaviour might be prohibited, for example, and over the years things get tougher and tougher, and then round about 2014 things took a really difficult turn when the court started to apply two tests essentially. Firstly, to consider whether the evidence was relevant, and only when they considered that the evidence was relevant would they even turn to think about whether 274 or 275 should be brought into the discussion. And that led to a whole series of decisions which many legal professionals in Scotland simply could not understand. And a variety of people, me included, complained that it was getting to the stage where accused persons, mainly men, because in my experience, where people are harmed in a relationship, it's usually a woman being harmed by a man. So generally men were affected by this and were not able to put questions to complainers about things that I always thought 99.9% of the non-lawyer population would consider highly relevant. But it had the additional difficulty that once the judge had decided at a preliminary hearing, which might be a year before the trial, that a particular issue was irrelevant, then the accused couldn't even speak about it if he chose to give evidence. And we saw some fairly bizarre episodes where the accused was really hamstrung. There had been a form of words which would be agreed, or there were issues which had been agreed, and then the accused found it really difficult to explain his position without transgressing on what had been agreed a year before. Anyway, all the accused can do in that situation is go to trial. If the trial is unsuccessful and he is convicted, he can then appeal on the basis that the evidence was wrongly excluded by the trial judge, and there have been umpteen appeals on that basis. I can't off the top of my head think of a single appeal that was successful. It was also possible for the matter to be determined pre-trial, so we saw examples of a judge granting permission for certain evidence to be brought into the trial. The prosecution would then appeal pre-trial, and the appeal court, the trend in the appeal court was to say that the single judge had got it wrong and that the evidence should be prohibited. I'm obviously in 15 minutes can only speak in the general sense, but there was a widespread concern that the rules were not being applied fairly. There is, however, a possibility of an appeal to the Supreme Court in very, very limited circumstances. You can only go to the Supreme Court either with leave of the domestic court or special leave from the Supreme Court itself on the determination of what's called a compatibility issue. And the compatibility we're talking about is compatibility with the Human Rights Act and the European Convention on Human Rights. So if your argument was there wasn't enough evidence to convict me in relation to that trial, you could never go to the Supreme Court about that, because that's not a fair trial issue. But if you were able to argue that because particular evidence was excluded, I didn't get a fair trial, then there might be the possibility of a Supreme Court appeal. And that's what happened in Keir and Daly. There had been domestic appeals in Scotland which were unsuccessful, and I don't have time to go into the whole process. It's probably enough to say that eventually they managed to get their appeals before the UK Supreme Court. I should say in passing that ultimately both appeals were refused by the UK Supreme Court in relation to the human rights ground. But I'll cover that in a different podcast, because it's quite a difficult issue to explain. So ultimately, at the Supreme Court, the only question for the Supreme Court really was whether the Article 6 rights of Keir and Daly had been breached. And the Article 6 right is in the determination of a criminal charge, everyone is entitled to a fair and public hearing within a reasonable time by an independent and impartial tribunal established by law. And the minimum rights include the right to examine or have examined witnesses against him, and to obtain the attendance and examination of witnesses on his behalf under the same conditions as witnesses against him. So that's really what the appeal was about. The Supreme Court had to determine whether Keir and Daly's Article 6 rights had been breached. But they went much further, because unusually the normal situation in an appeal would be that the only parties represented would be the prosecutor and the accused. But there was such concern in the legal profession in Scotland about this issue, the way in which sexual trials were being affected by the way the judges were applying the rules here, that both the Faculty of Advocates and the Law Society of Scotland sought leave to intervene. So in addition to the prosecutor and the accused persons, the bodies which represent all lawyers in Scotland were also represented, and they were there because of widespread concern in Scotland that men, usually men, were not getting a fair trial because of the application of these rules. And the headline last Wednesday was that the 5 justices of the Supreme Court agreed with us, that they went through the way in which the Scottish judges had been applying the rule in certain situations, and as it was put by Lord Reid, he referred to the jurisprudence of the European Court, previous cases in the European Court of Human Rights, and stated the approach which is currently adopted by the Scottish courts to the admissibility of evidence in cases of rape and other sexual offences is liable to result in violations of Article 6. It is not this court's function to decide whether it has done so in any particular cases other than the two appeals before the court. So Lord Reid was saying, well, all we have to decide are the cases of Keir and Daly. But by then, he had gone through a variety of other cases which were reported, cases which had gone to the domestic appeal court in Scotland, and torn the logic applied in those cases to ribbons. It essentially, on a variety of different cases, exposed the way in which they had been approached and expressed concerns regarding the fairness of all those trials. And so my question is, what happens to all those people? Because Lord Reid clearly thought in the cases of those people there had been breaches of Article 6, or at the least that they had been judged wrongly. And all of the cases which he referred to, as far as I can tell, were conviction cases which went to the domestic courts in Scotland. That's how he was able to quote from the reports. The reports generally are reports of live appeals which actually happened. And those appeals were all refused. So all of those men, applying a very simplistic approach to it, all of those men had trials, and Lord Reid, the most senior judge in the United Kingdom, had concerns about the fairness of those trials. In Scotland, you only get one appeal. They've had their appeal. So all those men who were affected by the judgments which the Scottish judges reached in those cases have had their appeals. Now, what happens? What happens to them if the most senior judge in the United Kingdom has expressed the view there was something wrong with the way in which their trials were conducted? Well, one of the reasons I was hanging off was to see what was said about that. And initially, it was a kind of Wizard of Oz situation that they're all going to wake up tomorrow and their convictions would have been quashed because of the appeal court. And then it moved on to the First Minister who was asked about it, and I'm not blaming him. All he could say is, well, the Parliament's independent from the judiciary, so essentially these cases will have to work their way through the courts. And then today, an official from the Criminal Cases Review Commission in Scotland said that him and his staff would be analysing the decision to see what implications there were. But I suppose the people who stand convicted are in three categories. There are the people who never did appeal, and it might be possible you've only got 14 days from conviction to appeal. Can't think why you wouldn't appeal if you thought that you'd been badly treated in the trial. But I suppose if they never had an appeal in the first place or didn't take an appeal in the first place, they could apply for leave to appeal out of time. That's likely to be a tiny group. I would imagine if you thought you'd evidence that proved you innocent, or at least shed doubt upon the credibility of the single witness in the case against you, you would appeal. So most of them will already have had their appeal. And in Scotland, you don't even have the right to go into the appeal court and verbally argue your case. A lot of appeals are just dealt with on the papers, as we put it, by judges considering the paperwork in their chambers. You get the chance to make written submissions, of course, but you're not there to answer any points that might arise. The judge just reads the paperwork and can refuse the appeal there and then. So there are those people who essentially their right to appeal has been exhausted, and they, I suppose, need to go to the Criminal Cases Review Commission, who I believe are already overworked. And what they do is they take references and then they investigate. Now, I don't know how many references they get in the course of a week, but I would imagine they're about to get several hundred from people who were prosecuted and convicted and thought that questioning that they wanted to put to the complainer was wrongfully prohibited. They've now got the 5 most senior judges in the United Kingdom essentially supporting the belief that some people were dealt with in that way by the Scottish courts. But can the Criminal Cases Review Commission cope with all that? Can they, deal with an extra 100, 200, 300 cases? And remember, the likelihood is if you're convicted of serious sexual offending, you will have been sentenced to imprisonment for somewhere between 5 and 15 years, I suppose, depending on the severity. So a lot of people will have been sentenced to 5, 6 years in 2014, 2015 and served their sentence. So what happens there? So I don't think it's good enough. The state caused this problem. According to Lord Reid, it was some Scottish judges who didn't apply the Human Rights Act in Article 6 of the Convention properly and failed to properly balance the right of the accused to a fair trial with the protections for the complainer, which 274 and 275 seek to give. So if the state created the problem, usually the state accepts responsibility for sorting it out. I mean, that's what happened. And eventually, took a long, long time, but eventually we often talk of the postmasters scandal as the biggest scandal in UK legal history. Eventually the government accepted that this is too much for the legal system to sort out on its own, that we'll have to have a scheme. We should have a scheme for this. And, given that it took the justices of the UK Supreme Court to correct the approach taken by the Scottish judges, we should have a retired judge of the UK Supreme Court available to review the cases of people who say that they were some of the people who were affected by the practice that Lord Reid and his colleagues were able to identify in Daly and Keir. I don't hear anybody saying that. I don't believe there is a solution to this problem in the Scottish legal system, which is really unheard of, for the justices to say that we've looked at the way in which this rule has been applied and all 5 of us are satisfied that you're failing to comply with Article 6 rights in the United Kingdom, in Scotland. So this is an issue which has to be tackled. And I don't think it's fair to leave it to the individual accused to tackle it. Generally speaking, there's a tiny cohort of solicitors in Scotland who are remotely interested in conducting appeal work. And I understand why that is. It's specialist work. And, you would get more money working in McDonald's than you would, dealing with appeal work. And solicitors are already under huge pressure to do work just to enable them to keep the lights on and pay their staff. So, there's no person involved in the Scottish legal system and the solicitor's profession who has got the luxury of being able to take a year away from earning to try and help these people who might have been wrongly convicted. So I think it's time for everybody to get their heads together and try and work out how we deal with it. The current way of dealing with it seems to be, well, they'll just have to work their way through the system as it stands. I don't think that's good enough. So that's my view on it. As I say, I'll come back and deal with some other aspects of the case, but I hope you found this interesting as an introduction. And if you have any questions arising from what I've said, by all means, send them to me and I'll come back on and I'll answer them. Okay, good night.